Well, as Kent said, I've been doing this 26 years and grew up on a dairy farm, or a small farm, as many of you know, and was a dairy farmer for 10 years before went to law school. So I've been a lawyer longer than I've done anything else, I think, now, which I don't know if that's a good thing or a bad thing. Going to try something new this year for this talk. I've got the slides here that we'll go through. I have had handouts in the past. I have some here, but in an effort to maybe go a little more paperless, not that it really matters for the number we have here, but I know a lot of presentations you go to, you don't have to fumble around with the paper. I'll go through the presentation. I number my slides. So if there's one, don't worry, you have to write everything down on it if you are so inclined. Just put down the slide number. And I do have some handouts that I'll put on the table here afterwards. And of course, this presentation, along with all of the presentations, I believe, at Iowa Pork Congress goes up on the Swinecast website within a week or so, I think, something like that. And so my slides will be available there. I want you to tell me, in addition to telling me how great the presentation is, just kidding there, folks. Anyway, telling me in your evaluations whether you like the idea of not having the handouts when I go through it. If you like it better next year, assuming they invite me back next year, and why then we'll do the handouts ahead of time. Just try something a little different, I guess. So with that, I want to get started. I am going to. I generally tell you what I'm going to cover and then try and cover it. We have an hour and 15 minutes. I often think it'd be great. Well, first of all, I always like to take questions as we go along. So if you have any questions, raise your hand at that time. Be glad to take the question. As you know, I'll repeat the question so it gets on the tape, so it's on the internet when which I know all of you watch this later, right? But also, maybe I can actually leave a little time afterwards so we can have some questions that you may bring up a topic I didn't cover. I'll try and cover everything that I think is of primary importance to pork producers, livestock producers in the state of Iowa. We're going to start with Cercla Reporting. Many of you have, many of you have been dealing with that in the last few weeks. I checked the EPA website this morning. This is one of those issues that just, you kind of put it aside. I first started dealing with this for Iowa Pork Producers Association in earnest in 2002. And here we are today in 2018, still doing the same thing. And my cynicism didn't come through there at all, did it? We got to go through it. It's a federal rule. The courts have ruled. We'll talk about that in a minute. We'll also talk about the DNR work plan and where that's at, and maybe some good news there that things are going pretty well with the work plan. We'll talk about nuisance lawsuits. I don't know if you can ever say that's good news, but we'll talk about an update there and where we stand. I'll talk about some of the DNR rules that went into effect a year ago. And I want to also include a little bit about maybe not directly a regulatory issue, but manure agreements and what I see issues in manure agreements where the pork producer, livestock producer needs additional land and enters into a written agreement. And I want to talk about some of the other agreements that, again, this may not be a regulatory issue, but if someone is putting up a building on a parcel of land, which a lot of we're seeing young people and others doing this as a good way to get started farming. I gave Jeff DeYoung a hard time a little bit ago. There was an article in the Iowa Farmer today that led right into my presentation today about how hog buildings and livestock buildings, feeding under contract, can be a great way for young people to get started in agriculture and farming. We'll talk a little bit about that. So instead of telling you what I'm going to keep talking about, let's get to it. Again, the slide numbers are there in the bottom right-hand corner of the slide. If I don't announce it, I hope you can see it. If you want to jot down notes, if that's what about a slide, I say, hey, pay attention to this slide in particular or whatever, and then when you do access the PowerPoint online or if hard copy, you'll have the slide number. And of course, I see some of you, you're always welcome to take pictures too, of the slides, not of me. Okay? All right. Not that you'd want a picture of me. Okay, here we go. EPA Air Emissions Reporting. Comprehensive Environmental Response Compensation and Liability Act. I don't know. I always have to read that. Cercla is what we're talking about. All right, a little background I don't have on the slide. Back in 2003, and I'll talk about this in a few minutes on the slides, the Kentucky Federal District Court ruled that livestock were subject to air emission reporting under Cercla and EPCRA at that time. And EPCRA is the Emergency Planning and Community Right to Know Act. That's probably the last time I'll say all those together. Anyway, the court ruled that livestock is subject to that reporting for air emissions. Kind of a surprise to a lot of folks. That was 2003. So then, anybody remember the Air Consent Agreement along in 2005, 2006, where you signed the agreement as a producer and paid a penalty, and then you had protection from not reporting under Cercla and EPCRA, pending the study that was done nationwide over air emissions. Well, that study was done, a report was released, and a panel of environmental experts with the government looked at it and said, we don't believe that is, be careful the words I use. They weren't ready to go forward with regulating using that study. In the meantime, in 2008, EPA issued a rule that trying to go forward, even before the study came out, that exempted livestock producers from Cercla reporting, and then EPCRA was required for anything over basically 1,000 animal units, 2,500 head of finishers. Well, that rule was challenged in court by environmental groups, and of course, we get a ruling in 2017. I see Dale holding his head already over what I'm telling you, right? Anyway, 2017, April of 2017, the court rules that EPA rule is invalid. Threw it out, no exemptions, you're back to reporting. The court just said that rule is invalid and nullified the rule. So now we're back to square one, back to where we were, in 2002, 2003. So that was in April of this year. Then we're on slide 3. EPA takes the summer to figure out, okay, what do we do now? The rule has been thrown out. So in late October, and under the court ruling, they had until November 15, based on the court ruling, to come up with something. Well, in late October, October 26th to be exact, they put a guidance out on the website, and there's the web address. That is one you should, if you're involved in this reporting, you should keep an eye on. But they, at that time, stated that the initial reports, which we'll talk in a minute, and many of you have done these already, but the initial reports were due by November 15. And that's what is stated on the website. And I'll just jump ahead here. What happened then? EPA filed a motion to extend that date. And that motion was not ruled on immediately. And November, for the 15th deadline to go into effect, the court had to actually issue what's called a mandate. I won't get into a lot of court procedure here, but the order, November 15 date did not, it wasn't a deadline that occurred on its own. The court had to issue a mandate on that date if that was to be the deadline. Does that make sense? No. But anyway, the court, when the motion by EPA was filed, that meant the court's, when there's a pending motion, the court wasn't going to issue the mandate. So the November 15 date was not the hard and fast deadline, and there was some confusion about that. But then, within a few days, the court issued a motion, or an order on the motion, and gave us until January 22nd to do our reports. Now, some had already reported by making the phone call or sending the email, which we'll talk in a minute here about the, exactly what's required there. Some had already done that, and then the question was, you have a 30-day written report that must follow that. Was that 30-day written report required to be filed within 30 days of you making the report or 30 days after the court issues the mandate, which was scheduled for January 22nd. EPA then put on the website, their guidance was, even if you had already made the phone call for the first initial report or sent the email in, you still have 30 days to issue your written report after the court issues the mandate, which was scheduled for January 22nd. Well, some went ahead and sent in the written report, which is fine. But right now, I'm not done. We're still not done. Deadline was January 22nd, where the court was scheduled to issue the mandate. Well, on the evening of January 19th, last Friday, with a government shutdown looming, you can't make this stuff up, folks. With a government shutdown looming, the EPA filed a motion for another extension, or what we call a stay, on the court's mandate. Once a motion is filed to stay the mandate, that means the mandate won't be issued until the court rules on the motion. So we found that out on the evening of January 19th, the Friday night. The government then shuts down. But we were assured by EPA on a nationwide conference call on Friday at 1 o'clock that the government shutdown would not affect the issuance of the mandate or anything like that. At any rate then, so January 22nd, last Monday, was not the deadline, again, because the court has a pending motion to stay the mandate to give EPA more time to develop these forms, and they've asked for 90 days from when the court, if the court approves their motion, whenever that will be, or until April 23rd, whichever comes first. So, pardon me, right now, where it stands, no reporting is required as we stand here today. Could that change by this afternoon? Might, I don't know. But all I can tell you is Tyler at IPPA tries to get the email out through the communicator. Pardon me? Yes, thank you. We're trying to stay on top of it. I know many of you are too. If you keep this website, if you're someone who is doing the reporting for clients, for yourself, etc., refresh that page daily, and I think the EPA will keep you updated. So, I'm not going to speculate because who can speculate on any of this, folks? It just keeps on going. All right, I've talked about where we're at, but what is the process? On the slide here, slide 3, again, I have the website. And the question, of course, is who has to report? The law says anyone emitting more than 100 pounds of ammonia or hydrogen sulfide in a 24-hour period must make a report under Cercla. That's what the court said, the law says. All right, how do you know if you're emitting more than 100 pounds of ammonia or hydrogen sulfide in a 24-hour period from your livestock operation? I think I saw Dan Anderson come in a little bit ago. I should make him come up and explain this, but the best answer I can give as a lawyer is, and Dan, you correct me if I'm wrong when I say this, all right? You'll be speaking later. I don't know if you're going to get into this. You're talking about cover crops, right? Raise your hand, Dan. Dan Anderson, Extension, ISU. I won't speak for Dan, but what I'm going to say as an attorney is nobody knows. Nobody knows how much is being emitted. Am I right? Dan says there's a large range, and they say attorneys don't give you a direct answer. Okay, and that's fair. I'm being a bit sarcastic, but nobody really knows. The best information we have, EPA has put some on their website, how you can calculate it, etc. The information, Dan, the ISU information you've put out is as current as we have, right? And for hog finishers, deep pit, the number is what, 2,700? So deep pit, swine finishers, the research we have, and there's other research out there, but at 2,700 head is where we believe you would start to emit. More than that, you would emit more than 100 pounds of ammonia in a 24-hour period, and therefore should report under Cercla. So those of you with the 2,500 head, under 2,500 head finishers, based on that information, are not required to report that you're not emitting more than 100 pounds of ammonia in a 24-hour period. Any questions on that? I'll just focus on that. Dan's information, is it on the Image website, Dan? Okay. Dan says that table I just referred to will, it went out at you, well, it'll be on the Image website tomorrow. And if you have any questions, let Dan know, pull him aside, or I have it here too, for anything other than the finishing operations. One of the other interesting aspects, a little sidelight here on Cercla Reporting. I know we're at a Iowa Pork Congress, you're pork producers, but I know some of you have cattle, some of you have cattle on pasture. EPA is taking the position that this law, the reporting law, applies to cattle on pasture. And I better be careful what I say, but I don't understand that. So, and I guess if you have cattle on pasture, of course the numbers get way up there before you would have to worry about it. Dan, you and I talked about a little bit about this the other day. Taking the numbers from a feed yard, you'd have to get up, what, about 600-700 head on pasture? Yeah. Pardon me? Yeah, so 880, 900 head before you had to worry about. I don't understand myself, and I'm not the one who makes this decision. I have a hard time understanding how the Cercla reporting law applies to cattle on pasture, and I'll leave it at that. Yes, sir. I'm going to repeat your question. So the gentleman said, has an EPA said that you have to add all sources on one farm, and that is correct. So if you had on the same site, and I'm going to get myself into a jam here, have to explain what a site is because EPA hasn't explained it. But yeah, everything on one farm has to be reported as one. So if it's cattle, hogs, etc., whatever emissions are occurring, you're to add together. You don't get to consider them separately, even though the an EPA guidance that's still online says you do keep them separate. But a court ruled, forget what year, that you have to add them together. Now, I brought it up. What is a site? That question has been asked of EPA, and they refer to contiguous properties. Okay, I'll wade into this, folks. I'll be, as long as you don't hold me to any of the answers I've given today, which I know you won't. But if you've got a 2,400 head finisher over here, and a half mile away another 2,400 head finisher, and you own all the ground in between, is that one site? I don't believe it is. I don't believe as I understand the definition of facility, even though you own all the property in between, it's corn and beans in between. You don't report corn and beans, pasture, whatever. No, don't say pasture. Hayfield, whatever it is. I believe those are separate sites. But if you have, two 1,200 buildings on one site, certainly you have to report those together. The EPA has also stated, I don't want to get ahead of myself, the 100 pounds of ammonia, how do you determine if you have met that threshold? Again, I think ISU has put out some very good data on that. There's other ways to calculate it. At this point, you don't, when you make the initial report, you don't have to tell them an amount. Let's see. I'm getting ahead of myself. I mentioned there, it's on slide 3, the EPA Air Consent Agreement from back in 2005. If you signed up on that for that farm, the EPA has said you don't have to do a report now. Now, if you built something new since then that's not under the consent agreement, you would be subject to reporting. Okay. Here's another ticklish subject to many people. Who has to do the reporting in a contract feeding situation? The grower or the owner of the animals? All I can tell you is what in 2003, a Kentucky court, it was actually a chicken broiler operation, the court said essentially both are responsible. Now, do both need to report? I think you report by farm. So I think as long as someone makes a report for the farm, I don't know that both have to, both could, but someone is responsible for that farm, and the court said both are responsible for that reporting, the contract grower and the owner of the animals. Okay, that's what the Kentucky District Court ruled under those types of contract feeding arrangements, which was a broiler contract. And the analysis was, as I had on slide 5, let me go back to that. The analysis of the court is, under the Cercla, it's the person in charge who has responsibility and power over the operation and can make timely discovery of a release, etc. I'll let you interpret that court decision. If you're questioning who has to report, I'll let you go through that with your advisors. Okay? But that's what I read under the court decision, that both the contract feeder and the owner of the animals, the contractor, at least in that case, was a person in charge. For leased facilities, if someone is leasing your hog building and you have nothing to do with it, you don't take care of the animals, you have no control, you're leasing it out, the court in that case was clear that only the tenant was responsible for reporting. The owner of the buildings who was leasing them out was not a person in charge and not responsible for reporting. Okay. Slide 7, I've already talked about pretty much on the deadlines. Okay, then we also lay out on slide 7 how you do your reporting. All of this is on the EPA website. First of all, there's an email you can use. There's the email address. What do you have to have in the email? That's the initial step. The email, what we call the initial continuous release reporting. You're supposed to, first of all, note that it's initial continuous release notification, the name of the farm, location, and EPA has made it clear you don't have to give any more than the city or town and state and the name of the substance released. Essentially, 4 things have to be in that email. My advice is give them those 4 things and nothing more. Nothing less, but nothing more at this time. And the EPA has said you can include more than one farm in an email. All right? Again, when the court issues its mandate, whenever that is, and we'll keep you up to date, the first step, if you haven't done it already, is to send in this email. If you have, some of you have already done this initial report. If you have, as I said, the EPA guidance says you don't need to do this 30-day follow-up written report until 30 days after the court issues the mandate. So let's say we do get until April 23rd, whenever that is. Then if you're sure you have to report, if you're certain you're over 100 pounds and you're certain you're going to make the initial report, you can go ahead and do that and then just wait if you want to until the court issues a mandate, and then you'll have another 30 days to send in your written report. That written report is much more detailed. I'm not going to go into the details here. We'll be getting information out about it. NPPC has sent out information through IPPA. Other organizations have. Other companies have. EPA did state in their motion for this stay of the mandate until hopefully the end of April that they need this additional time to work on their reporting forms. So I do, I'll get myself in trouble again, but always be careful when government says they're going to simplify something, all right? But I think they're looking at some maybe simplified forms. I'm not sure, but they did say that's why they need this time. So stay tuned. My advice would be to say, hey, wait and see what happens. I know some of you have already sent in your written report. You're all done. What's the next step after that? After all this is done, then you're to follow up with at a year's time with the follow-up report. In the meantime, if you have a significant increase for whatever reason, you are to report that. Last time we had to go through this back in 2008 under the EPCRA reports, and the only difference between EPCRA and Cercla, because now, and maybe I didn't point this out, EPA has said we are exempt from EPCRA reporting because we have routine agricultural emissions. Keep track of this, folks. Before in 2008, EPA said we were exempt from Cercla but had to report EPCRA if we were over 1,000 animal units. Now, EPA is saying that we have to report Cercla, but we're exempt from EPCRA. Again, you can't make this stuff up. So, EPCRA, and I believe that EPCRA, that has been endorsed by the court in denying a motion on EPCRA. EPCRA did not have to be reported under. What's the difference? Under EPCRA, remember back in 08 and 09, we had to make the call to the local emergency response coordinator and the state emergency response coordinator, i.e. DNR, in addition to doing the federal reports. So under Cercla, you only do the federal report. I know the people that are extremely pleased right now about all this, and those are the local emergency response coordinators in the state, because they don't want those phone calls. They don't want those notifications. It bogs down the system, etc. DNR issued an email that said, in essence, please, please do not send those reports to us. They go to the national emergency response coordinators. That's the difference between Cercla and EPCRA. The levels are the same. Okay. All right, I'm moving on to work plan. Any questions on Cercla? Yes, sir.
The email that you send them, before you can make a report, they have to come back to you with a case number or something? Is that the implication of that?
Yes.
Until you see that, you can't really do anything, right?
Correct. I'll repeat what you just said. When I didn't have it in the slides, but it's in some of the other information we've put out. When you send in the email, and maybe I can't. Maybe I did have in the slide. When you send in the email, they are to respond with an automated response with a number, and that I think they have said it'll take some time. They'll get a number back to you, and then you use that number on your written report. Now, and I'm not with the government, folks, but how many of you have done this already? Just okay. Have you done it for multiple farms? You took away my thunder. Who said that? Did you get the same number for everyone?
I didn't get a number.
Oh, okay. Nick, you said that, and that's what we're hearing is everybody gets the same number. I have heard reports that somebody reporting from North Carolina, and I'm just giving examples, and somebody's shaking their head yes. Somebody from North Carolina may have gotten the same number as somebody from out west. Those are just pure hypotheticals, nothing. And for sure, if you have multiple farms in the same email, my understanding is you'll get the same number. So, yeah, I'll get myself into trouble if I keep talking. So I'll be, but yes, you need that number, and that's what you get from the email. Okay? Any other questions or anecdotal information you want to share and help me get into trouble? Yeah.
So this is a problem that Congress made, and only Congress can fix it. This supports a rule. There was a rumor going around that Congress was working on a fix. Have you heard anything recent about that?
The question was, again to repeat for the internet here, that, and I'm repeating your words, that this is a problem Congress made, so Congress needs to fix it. And that is I'll stop there. That is a correct statement because the EPA tried to fix it, so to speak, in a rule, and the court threw it out. So, yes, I believe the only way we're going to get any true relief from any complete exemption beyond what the EPA has given us here would be if Congress would step in. So then the question was, there has been a rumor that Congress is looking to fix this. I think it's more than a rumor. Tyler's not in here with Iowa Pork, but I know there was a letter circulating among some Congress members to try and handle this through a funding bill and not give funding to EPA to enforce this. The problem is that doesn't help with the courts. The court has said you need to do this. I think the only way Congress can fix this is to go into Cercla and EPCRA and just make a clear exemption. Boy, if I don't know when, and if they did that. Boy, you like me? See how I'm stumbling around here? Because if they would do that, that would fix it. What is the likelihood of Congress going in and actually granting an exemption in Cercla and EPCRA? I'm not going to say about that. I know they were looking at the funding mechanism to, like they have done before, to not provide funding. I just don't see how that trumps the court decision, because the court has said, you got to do this. And whether there's funding or not, the court has ruled. So I think Congress, to fix it, has to go in and amend Cercla and EPGRA to give us an exemption. Talk to your Congress people about it. And I know there is some talk about that. I don't know how likely that is. Okay. 10-minute answer to a 1-minute question. Okay. Any other questions? All right, should we talk about DNR and the EPA work plan? We're 4 years. I've got a slide at the end here. I'll probably kind of rush through these slides. I like to ask, how many of you have had these DNR inspection work? We call them work plan inspections. Others call them audits, etc. How many of you had? Okay, not a lot. There may be some to go. As we note on slide 9, DNR, it's a 5-year plan, and so the 5 years is up this year, September of 2018. They do desktop assessments in addition to on-site assessments. Of course, backing up a little bit, this is all a result of environmental groups filing a petition with EPA a little over 5 years ago, asking EPA to take the animal feeding operation program away from DNR because they, in essence, weren't doing their job in requiring NPDES permits for livestock operations in Iowa that should have otherwise had them. As a result of that, DNR entered into an agreement with EPA in 2013 to do either on-site assessments or desktop computer assessments of every livestock operation in Iowa that pretty much above 300 animal units is where the break would be. DNR has been working on that since 2013. On slide 10, we show the priorities of doing those assessments, and they started with, in this order, animal feeding operations with spills, releases, complaints, involving discharges to the waters of the U.S. Then they went to the large open feedlot CAFOs and the medium-sized open feedlot CAFOs, or animal feeding operations, and combined operations that have both. Then they went to the large confinements. And now, I think most field offices should be down, because we're into the 5th year, to the medium-sized confinements, and that would be your confinement operations below the 2,500 head, between 2,400, 2,500 head. So if you have those type of operations and DNR hasn't either contacted you to say they've done a desktop assessment, or if they haven't contacted you to do an on-site inspection, they could well be doing that in the next year. DNR's hope, and I'll talk a little bit in a minute about their progress, it appears that DNR is on track to be done at the end of the 5 years, which would be this September. I'm going to skip over slides 11, 12 on site inspections. I'm going to stop on slide 13. This all was intended, well, I won't say what I really think it was intended for, but it was aimed at whether our livestock operations, including confinement operations, needed NPDES permits and didn't have them. Under Iowa law, confinement operations cannot discharge. They must retain all manure produced between periods of manure disposal. Feedlots have some standards where they can discharge if they have an NPDES permit and greater than the 25-year, 24-hour storm, etc. But confinements, we don't get that. Okay, you have to retain it. So, I guess where I'm headed here is it any surprise we haven't found any that are discharging because the law doesn't allow you to discharge? No, there have been no confinement operations that I'm aware of that have been found to have discharged. Now, accidental discharges are a different matter. Before somebody throws something at me, if you have a manure spill, that's an accident. Hose breaks at something. Those are accidental discharges, and you're not required to have an NPDES permit for an accidental discharge as long as you fix the conditions that cause the discharge. But in the normal operation, if you don't discharge, which Iowa law doesn't allow you to, then you don't need an NPDES permit. And so far, the DNR's On-site and desktop assessments have borne that out. Plus, open feedlots, in my understanding, I also work with quite a few cattle operations and the Iowa Cattlemen's Association. Those inspections have failed to turn up any. I mean, there's some operations, just like confinements, that need to maybe improve on some practices. But these inspections have borne out that our industry is doing a good job. We have a year to go, so don't stop, folks. But we are doing a good job, and this 5-year inspection plan has borne that out. Okay. I have some slides here about what you need to do. Backing up a little bit, if you're contacted, DNR is going to stop out. Those of you who have been through this, you were contacted ahead of time, right? And they set up an appointment with you. And either you or your consultant were present, and DNR does. If they did an on-site, they generally walked around, took a look at your operation, checked out if you have a composting site. That's one area you need to pay close attention to for mortalities. Looked at your manure storage, etc. In general, how long did these inspections take? Give me a ballpark.
1 hour.
What'd you say, Keith?
1 hour.
And you said 1 hour, yeah. Anybody? So not a lot of time, but again, they show up, you go with them, they do the inspection, then you usually get a letter within a couple weeks that says the results of what they observed. And again, by and large, everything has went very well. And again, I think we as an industry, I'll say you as an industry need to pat yourselves on the back, but we have a year to go, folks. Keep up the good work. They're now down to the, as I said, the medium-sized operations on their priority list, and so again, their plan is to be done by the end of the 5th year this fall. A note here on slide 14, DNR will not enter confinement buildings, and they absolutely, I'm not aware that they ever have. And so you shouldn't have to be concerned about that, but if an inspector does say something like that, the DNR policy is not to enter the buildings. Also, if they are to follow your standard biosecurity policy, so make sure they know about that when they call to schedule the inspection. I encourage people to do their own audit before DNR gets there, and just do an environmental review of your own operation, and then you can be ready if you need to correct anything. You can certainly do that. Okay. You should also ask for a copy of the desktop assessment before they do an on-site assessment. You're entitled to that. I think DNR will generally provide that, which shows why they're doing the on-site assessment. Okay. During the inspections, DNR is to review MMP and other records, and then ask about the maximum number of head confined, and they will have the records that show that. Then during the inspection, I already talked about what they are to look at: manure storage, manure stockpiles if you're a dry manure operation, perimeter tile inspection, ports and outlets, feed storage, mortalities, and then areas downhill of the operation, because they're there to try and determine if there have been any discharges or if the operation is discharging. Okay, I talked about on slide 18, you'll get a report within a few weeks, and it'll often have recommendations and then anything that you would be required to do under the law. Okay, slide 19. This is kind of my summary slide of the work plan. Again, you can find these. DNR was required to give reports to EPA. These are on this website. If you Google EPA/DNR work plan materials, it'll pop up. The August 1, 2017 report, the most recent report of DNR, they have completed the 4th year of the work plan, as we talked about. They are 88% through the baseline inventory of all of the operations, doing either a desktop or on-site inspections. So at 20% a year, they are ahead of schedule. And they have 172 total active NPDES permits. To my knowledge, those are all open feed lots or combination lots. confinement operations. I'm not aware of any that have an NPDES permit because, again, under Iowa law, they cannot discharge. Then this was in the papers and somewhat drew some controversy. DNR noted in their report that they identified 5,063 additional animal feeding operations that need further investigation to determine their regulatory status. Now, we don't have anybody from DNR here, but my understanding is, and have any of you, I have a client who got a letter in the mail that said, we've identified through, I believe it was assessor records and through satellite imagery, that you may have an animal feeding operation. Turned out to be a machine shed, okay, in my client's case. Have any of you gotten a form like that? It's my understanding what DNR is doing here, as they were required to do by the EPA in the work plan, is try and identify any operations they have missed. They came up with this number, and right away there were those that said, oh my God, you've missed 5,000 animal feeding operations. And DNR has been quoted saying they do not believe any of these will, I don't know if they use the word any, but it is not believed that there will be very many, if any, that are of a regulatory status, which of course for an NPDES permit is above 300 animal units. But they are going to take, my understanding is, the next 2 years after the work plan ends to check into these, and then they will issue a final report. So if you or your clients get a letter questioning whether it's an animal feeding operation, again, it could well be, you know, a machine shed, a greenhouse, something like that, or maybe they aren't using it anymore. They just need to respond to DNR what it is, and that should be the end of it. Okay? I think that 5,000 number was reported, it was misunderstood, and I think DNR has admitted they probably could have worded a little different in their annual report to have more fully explained what they meant by that. But at any rate, that's where we stand with the DNR work plan. Any questions? All right. Now I want to switch gears. I mentioned this in the beginning. We're on slide 20. And again, I've got a few hard copy handouts of the slides I'll put up here. And as I said before, they'll be available on the website. I want to talk about not necessarily a regulatory issue, but I want you to know as an attorney, I do still read the farm publications. If you're here with the farm publication, I try and read as many as I can. I get Iowa Farmer Today, not to promote that, but a good publication. Many of you get it. And what's the cover story of this week's publication, or this week's Iowa Farmer Today? It's a story. Jeff DeYoung's in the back, in the back about, pardon me, about a young farmer, young man from southwest Iowa, I believe, who hog contract feeding and his hog building is helping him return to the farm. And this story talks about other, others who are doing this. And again, we've known this, and my job is to report legal issues, but it is good. It's refreshing to see stories like that, how a young person like that can get back at the home farm, get back into agriculture, and livestock is what's helping him do that. And Kent Maurer with the coalition works with a lot of young producers like that on how they can get back to the farm, how livestock helps with that. And Kent introduced me, and raise your hand again, Kent. You're always there with the coalition to help producers figure out the rules we're talking about, along with financing options, et cetera. You just had a conference on that, right? So at any rate, my slide 20, I try and lay out what are the legal documents that someone might need to do that, or even if you're not a young producer, if you're wanting to parcel off a piece of land, if you're the landowner and you want a hog building there, but maybe you don't want to have to take care of the hogs, you don't want to have to deal with the hog building, but you want the manure, but you know a young farmer or any farmer, that pork producer who wants to have hogs there but doesn't have the land base. Well, first of all, if you're going to parcel the ground off, you need a deed, of course, selling the ground, Or we see producers do what we call long-term ground leases, where they hold on to the ground, don't sell it, but then allow someone else to build the building on the land under a long-term lease, ground lease, a severance agreement. So they own the building on somebody else's land, and all I'll tell you there is make sure the legal documents are in place and that your lender is comfortable with it, because you're putting a building on somebody else's land and you don't just back up to that with the John Deere and pull it down the road. And this is common in commercial buildings. Half of downtown Des Moines, probably the land underneath those buildings is owned by somebody else. But we're seeing that can be done with livestock buildings. If you do deed off your land, if you're the landowner, many landowners, want to have control over that in case the producer who buys the land ever sells it to somebody else. They want to have what we call a right of first refusal to buy it back. That should be in the deed. You're going to need a manure easement/agreement. I'll talk about those in a minute. What we call a non-disturbance agreement if there's a mortgage holder there, so the mortgage holder agrees not to, if they have to foreclose for whatever reason on the land under a manure agreement, they will leave the manure agreement in place. You may need a building lease if you're leasing it out to somebody else, or you may need a feeding agreement if there's a contract feeder involved. And then the DNR requirements, of course, the MMP, construction design statement, and a permit depending on how large the building is. But that's just a general overview of what to look at if you're the producer or the landowner who want to, again, enter into an agreement for buildings to be built on that land. Manure agreements, manure easements. Many of you manure management planners work with these quite a bit. Let's start with the DNR requirements. If I own the hog operation and I'm putting manure on land that I don't rent myself or own, which I have in the slide here, then I need a written agreement to satisfy DNR rules to get my MMP and my construction permit or my construction design statement approved. It's pretty basic what DNR requires. It has to have the number of acres available and the length of the agreement. No minimum length. It has to be at least one manure application season, etc. But very short. I don't advise you just sticking to those requirements to satisfy DNR. From a legal perspective, slide 22, if it's going to be long-term, and most lenders want something a little longer term than 1 year for a hog building or any livestock building, I just list some of the things there I think you ought to look at in those agreements. And we do have some information on the IPPA website on manure agreements. We're updating that information here shortly, and you can work with your local attorneys on a manure agreement. It should be binding on future owners. That is, the legal term is run with the land. So if either the hog operation or the manure, the land where the manure is applied is sold, transferred for whatever reason, your manure agreement goes with it. It should state whether the crop landowner is required to take the manure and whether the hog producer is required to provide the manure. Some say the producer has the right to use the land to apply it, but is not required to apply. Many landowners, if they're going to sell off a parcel for a building, they want that manure, and so the agreement has to say, it should be clear that the hog producer is required to provide the manure. We'll talk about some court cases here in a minute where that was the key issue. Who pays for manure application? Is there any payment for the manure? And if so, is it valued according to crop nutrient value of the manure? And then, of course, what is the liability of the parties? Who's liable for what? There are other terms that should be in there, but that's a basic overview. Okay, next 3 slides, starting with 23, have to talk about court decision. All 3 of these court cases are on manure agreements. And I've had attorneys tell me, I never thought I'd see people go to court over manure. But they don't know what we know. We know how valuable that is, and I think these cases illustrate that. In all 3 of these cases, and as I look at the clock, let's see, I go till 10:30. It's a little after 10, so we're in pretty good shape, but I want to move right through this. In all 3 of these cases, what happened was You had the original parties who entered into the agreement for the hog building and the land where the manure was going to be applied, and the landowner who sold it off. The original parties that worked fine. What happened was somebody bought the hog buildings, okay? And when that somebody bought the hog buildings, they took a look, and I'm not casting aspersions on anyone here, I'm just reporting. But they looked at the agreements because maybe they didn't want to have to apply manure to that land. They wanted to put it somewhere else. So it's the people, the next ones down the line where these court cases had occurred. And in the first case I'm talking about, a 2009 case, the deed itself reserved the right to all the manure for the landowner that was selling off the buildings, but the manure agreements didn't. And so the court had to look at, okay, I got a deed that says the landowner still gets it all. I've got a manure agreement that doesn't. And the court ruled that the manure agreement controlled over the deed. I won't get into the legal issues. So that landowner who sold off those buildings did not, once somebody else bought the buildings, didn't get the manure anymore because the new building owner wanted to use it somewhere else. Not what the landowner had in mind. 2016 court case that went to the Iowa Court of Appeals. They had agreed in the real estate purchase agreement to enter into a written manure agreement. And I'm smiling because we all get busy, don't get things done. They never did. There was an oral agreement between the building owner and the landowner, and it worked fine when that person owned the buildings. But when those buildings were sold, the new owner said, hey, hold it. New owner was I misspelled seller there, didn't I? The new owner allowed the seller to have the manure for 1 year, but then decided they could use it somewhere else. So, and the court here, though, now this is one of those cases where you can say they didn't have to have a written agreement because the court held the oral agreement was valid and sent it back, what we call remanded it back to the trial court, and then the case settled. So the person with the oral agreement, the court said, you have a binding agreement. That isn't going to happen in a lot of cases. I am here to tell you, we attorneys always tell you have it in writing. The second thing is, you know what it means when it goes to trial and then goes to the appeals court and then it goes back to the trial court? It means attorney's fees. That's what it means. And it means a lot of expense. And I can say that. I'm an attorney. I can give attorneys a hard time. It cost a lot of money to enforce that oral agreement. The written agreement would have saved a lot of trouble, and I'm sure both parties thought, why didn't we just get that done? Why didn't we drop, shut the combine off? Whatever you had to do to get it done. Ultimately, again, I assume they got to where they wanted to be. They settled out of court, but it sure cost a lot of time and money. 2017 case just came out last year. Another case where the building sold, and the court had to go through the terms of the easement. And one of the things the attorneys argued here is that an easement is only binding on the party that is getting the manure and allowing them to enter their land to apply the manure. And the court said, wait a minute, these really aren't true easements. These are agreements where both parties are bound. Worth the legal argument on behalf of one side, but the court said, no, that, again, a true easement is where one party just says, you can do something on my land, and really the other party isn't bound to have to do that on their land. These manure agreements, if they're worded like the parties usually want them, where the landowner wants the manure, not just allow access, but requires that the manure be spread on their farm. Then it was converted from a sow unit to a finisher, and there was some discussion and argument in court about how much manure does that involve when it was originally sow manure, etc., and a corn-soy rotation. I won't get into all those details. You can look at it on slide 25. If you're really interested in these cases, you can go online and find them, or let me know and I'll help you find them, or I can get you more detailed summaries. Also, the court said they validated using a term in an easement, a manure agreement, to value the manure based on commercial fertilizer. The parties that argued, no, you can't do that, or one party did, and the court validated expert witness testimony and an expert, how the manure agreement was worded to value it based on the value of commercial fertilizer. Any question on manure easements? Okay? Again, I think a very important document. Can I, do you mind if I get up on my soapbox here and give you a little attorney lecture? Okay? Bear with me. All right. I'm an attorney. And those agreements that are out there where they have blanks where you can insert party names and blanks for signatures at the end and you photocopy and use them, I love those, folks. I just love them because, okay, my tongue's right in my cheek here, all right? I'm giving you the Pennzoil speech, okay? Well, I'm showing my age there. I think they quit those commercials years ago. You can pay me now or you can pay me later. Those photocopying agreements and filling in the blanks, okay, if you go through the agreement, you read all the details and it's all correct, what you want, perfect. Otherwise, I know you're saving some time and money on the front end, but often, and when I get calls and I say, one party, when the caller says, well, they're not doing this. Well, I read the agreement and I say, well, the agreement doesn't require them to do that. Well, but that wasn't what we talked about. I don't care what you talked about. What did you sign? What's in the agreement? All right, done with my lecture, okay? All right, thank you. Okay. Ag nuisance cases. And let's see, time-wise, I'm about 20 minutes out. I'm going to, as usual, I always think I'll have extra time, but it seems like there's always plenty to talk about. Okay, I don't know that I need to go through, what an ag nuisance case is about. We've talked about this in past years. We're on slide 26. And nuisance cases in Iowa are odor. And most ag nuisance cases are odor, some claims of flies, some with dust, etc. But when it gets to the jury, normally it's all about odor. It's the unreasonable interference with the use and enjoyment of property. We talk about the witnesses, fact witnesses, expert witnesses there on slide 26. I'm going to move to the next slide, slide 27. What can we do to stay out of a nuisance case, which is what you all want to do? Sometimes this works, sometimes it doesn't. Location is extremely important. Of course, separation distances, prevailing winds, and topography. Tree buffers. Kent, the coalition works closely with farmers on your tree planting program, right? Research has shown that tree buffers do help mitigate odor. Building ventilation management, and then management of manure storage. I'm a big believer, as many of you know, on that ventilation system that you folks spend a lot of money on is a big factor in odor control and nuisance. Clean pigs, quote unquote, happy pigs, ventilation is right. They don't lay in manure and make a mess to try and make themselves comfortable. When that manure goes through those slats into the pit, there is less odor than when that manure is on the pig. So don't let people sell you short on what you spend and how much time you spend on building ventilation, because it is an important odor control tool. Okay, moving on, insurance. I'm not selling it, but there are people who do. Some of them are upstairs. Normally your farm liability policy does not cover nuisance actions. I have a couple of court decisions there. Illinois in 2013 it did. Wisconsin it didn't. Don't take the chance, folks. Most of the time your standard farm liability policies will not cover you. There are, again, policies that will, but you have to get an endorsement or a rider. Check into that, especially for these young producers we've talked about who are putting up buildings. Make sure they have protection here. Slide 29, I kind of cover some of the details, and as with anything in insurance, read the coverage you have. Make sure you are getting the coverage you're paying for and that you want. Okay, nuisance defense laws. Right to farm laws, many people call them, slide 30. All 50 states have these laws. Indiana has probably one of the best laws, and as the courts we've got some very favorable court decisions in Indiana about their law. Missouri Supreme Court decision in 15 upheld their 2011 law. That is, any of you with buildings or from Missouri, you've got some very good protections in Missouri now. And then the least favorable court decisions for producers, right here in the state of Iowa, we've had 2 Supreme Court decisions finding our laws unconstitutional, various aspects. I'll go to the animal feeding operations nuisance defense that was passed first in 95, amended in 98, and 2004. The Supreme Court found that it was unconstitutional as being unduly oppressive under not under a takings clause, but under the inalienable rights clause. I'll not get into details there. At this point, now we have a new law, and then we'll come back to that law because we have a court decision coming, and on February 12th there's an oral argument in the Iowa Supreme Court about our 1998 law. It's going to be revisited as to whether that law is unconstitutional, it appears. 2017, Iowa legislation, House File 468, Senate File 447. Many of you followed that through the Iowa Pork Producers Association and others. This law takes a little different approach. This law limits damages. You don't have what some people call immunity, full protection, and that it's found not to be, that you're not a nuisance. This law says if the jury were to find that your operation is a nuisance, then damages are limited if you follow generally utilized management practices. In other words, are doing the things in your operation that you should be doing and under industry standards to control odor. But go down to the last green bullet point there. The damages are limited to decrease in fair market value of the property. If there is a nuisance, the jury finds there's a nuisance, then the jury is to look at the testimony about what was the property, the residence worth before the nuisance was occurring and what is it worth after. Those are the damages that the jury can award there. Any damages for a medical condition, I've been doing these cases for many years. I've never seen it actually brought to court, let alone proven in court, of a medical condition for any neighbor suing for nuisance. But if there are damages for that, this law would not impact those. Those would be allowed. And then the third category, special damages, you would take number 1 and number 2, add them together, and then the jury could award up to 1.5 times that for the loss of use and enjoyment, what we call the special damages. Okay, that's the law that was passed on March 29th, signed by the governor on March 29th, went into effect that date. It, however, cannot apply to what we call accrued or existing causes of action. So if there's a nuisance occurring out there as of March 29th, the law could apply going forward, depending on how judges rule. But certainly, well, it cannot apply going backwards. That would not be constitutional, and that's how the law was written. Mainly what we're looking at here, folks, is protection, I think, not mainly, but I guess the primary category would be operations, buildings built after that date, these new buildings going in, young producers I talked about, et cetera, need to be aware of this law for protection. But the key under this law, like any of our laws, they have to follow generally utilized management practices. You have to be a good operator to get the protection of this law. So don't think this law protects you just for whatever you want to do. And here I go again preaching. You have to follow those good management practices. If you do, hopefully you're not a nuisance to start with. But if you follow those practices, do what you're supposed to control odor, and somehow are still sued for nuisance, found to be a nuisance, you have the protection of this law. If you have any questions, let me know. Okay. We had an ag nuisance case in 2015 in Poweshiek County where the jury awarded ultimately $462,000. We've talked about that the last few years. A case that caused a lot of concern for producers. One neighbor was very close, 2,200 feet. I should say close, 2,200 feet outside the separation distance for a under 2,500 head building. But and they were to the northeast, north-south road. The building was on the west side. the residents on the east side, so it was a bit northeast. That case was appealed, and the appeals Court of Appeals, the first step in the appeals court process, upheld the trial court and ruled, upheld the $462,000 nuisance case, that the trial court decision. But that case has been what we call asked for further review to the Iowa Supreme Court, and when I just checked last week, that had not been ruled on yet. So I don't know if the Supreme Court's going to take it up or not. Case went to trial in Iowa in 2016, and again, I'm starting to run out of time, so I'm going to move a little quicker here. That case in Wapello County we talked about last year. Jury, after a three-week trial, the jury ruled no nuisance and awarded $0 to the neighbors who were between 1.2 and 2.5 miles away. And after trial, they ordered almost $50,000 in court costs, not attorney's fees, but court costs to be paid by the people bringing the lawsuit. And I note there that before trial, one of the defendants, the contract grower, used a legal maneuver or a legal approach called confession of judgment, and offered to confess judgment for $60,000 to avoid trial. And the plaintiffs, the people bringing the lawsuit, accepted that, so there was that $60,000 offer there. But the owner of the pigs went to trial, and the jury ruled in their favor that there was not a nuisance. Okay. Now, slide 35. We have a couple of recent cases, one very recent and one from 2016 from other states. Not Iowa, but I know some of you are interested in those states, may have operations in those states, etc. In Scott County, Illinois, about an hour west of Jacksonville and Springfield, in May of 2016, a jury found that two 7,500 head swine finishing farms that were a quarter mile apart, that for 10 plaintiffs, 5 residences that were between 1/10 of a mile and 1.5 miles away, no nuisance and no money awarded. One of the residences was actually in between the two operations. And again, I can give you more detail. Come clean with you. I helped with that case. And so I know some of the facts. Primarily, I think it was the jury heard testimony from other neighbors who lived just as close or closer than some of the plaintiffs, and heard testimony from them that they said it was not a nuisance, and the jury ruled that it was not a nuisance. Then we just had a recent decision in Todd County, Minnesota, which I believe is about an hour or so northwest of the cities. 3,200 head sow farm. 6 plaintiffs, 6 people suing, 4 residences, and they ranged from a quarter mile to a half mile away. I think the one to the north was a quarter mile, a couple to the west, and then one to the southeast of this sow farm. And on December 15th, the jury came back with a finding of no nuisance and awarded no damages. Talked with the producer about this, and it appears that one of the critical issues for the producer in this case was expert testimony, odor modeling that was done, that the jury really focused on the science behind what the producer was doing for odor control and what they did to determine if what odor was being emitted, and modeling, etc. So again, another decision finding that there was no nuisance. What do we have on file right now in Iowa? Slide 36. We have 8 coming up, and here again, this is the legal system and lawyers for you. A lot of these, we had none go to trial last year. Some were scheduled, they got continued, postponed, etc. But we have, earliest one is a small cattle yard in April of this year. Then we go to some swine finishers down in southeast Iowa, July, September, into December then, and then a cattle feed yard into January of next year. That cattle feed yard was first scheduled for trial, I think, 2 years ago, and has been continued. I'll tell you why here in the next slide. Then the newest case that's on file is out of Jefferson County, a swine finisher, and it is just been scheduled for trial in June of 19. Okay? That's the list. I'm sure a good chance it'll change. Here's one, slide 37. I mentioned a Supreme Court oral argument coming up. This was out of Wapello County. It was filed, it was set for trial in August of 2016. The attorneys for the pork producers have filed an appeal, what we call an interlocutory appeal, or that's an appeal before trial, on the constitutionality of our animal feeding operations nuisance defense. And the argument is, court, you need to revisit it. Things have changed. We have different regulations. And the attorneys for the pork producers the producers in this case, an Iowa Pork Producers Association has filed a brief in support of the pork producers in this case, arguing that the law is being misapplied by the courts across the board when in fact the court decision in 04 said you need to do it on a case-by-case basis and look at the individual facts. And we believe, the producers' attorneys believe the facts in this case, at least for some of the people who are suing, should mean that it is constitutional and should be upheld. Oral argument is set for February 12th. It's a Monday night. If you go to the website, if you're real interested in this, they broadcast the oral arguments on the internet, and you can watch the oral arguments on this case at 7 o'clock in the evening, February 12th. Okay. Separation distance waivers, switching back now away from nuisance. We're seeing a lot of these waivers. You know, I say a lot, but those of you who work with locating hog buildings know that some neighbors who live too close under the law, live within the 1250 or the 1875 or whatever the distance is, will sign waivers. They're fine. They want to waive the application of the law so the producer can build the buildings. The DNR rules I lay out there on the slide. The title holder of the residence needs to, both title holders need to sign it, and there was a new DNR rule a year ago. I'm not going to probably run through all the new DNR rules, but from a year ago we covered those at last year's Pork Congress. Nothing's changed since then, but the waivers do have to be specific as to the buildings that are being built, and if the waiver covers anything in the future, it has to specifically describe what the future plans are. You can't have these open-ended waivers that don't describe what's being built. That's under the DNR rules. Other issues I have at the bottom of page 30 or slide 38. If you're using and if you're working on these waivers, here I go again promoting attorneys. But I've seen waivers, corners try to be cut, and it can come back to bite you. I'd encourage you to use a local attorney. You need to make sure you have the right legal descriptions, and you need to make sure you have the right property owners. Those of you who work in this area know that it's surprising how many times people don't know how they actually own their property. It could be in a revocable trust. It could be, oh, I didn't realize sometimes they just don't realize actually how they hold their title to their property. You need to make sure you have all this correct, because that's a pretty important document there, these waivers. Okay. Let's see. I'm at the end of my time. The rest of my slides, I cover common ownership and management DNR rules. Nothing's changed there, but stay tuned. There's a lot of discussion about, sites where you have different ownership, different management, even though the buildings are closer than the adjacency distance, and how those are interpreted. All I would say is be very cognizant of what you're doing when you set that up, because if at some point, if you have father-daughter, father-son, whatever it is, and you have different ownership and different management on buildings that, if they had the same ownership or management, would be considered one site, you need to pay attention to what happens when father retires, etc., or mother and father retire, etc., and those buildings come back together. My interpretation of the law is then you're one site when that happens, and you need to then be able to meet the requirements of the law at that time. So look ahead when you do that. Splitting ownership or management now, again, it's It's something you need to think very carefully about. I can tell you what the law is. You need to make the decision, but also think ahead as to what's going to happen in the future if those buildings come back together as one. Then you need to look at how will that person comply with the law then. With that, I've taken the time as I usually do. Sorry, if you have questions, I think we have a few minutes here. Not much, but I will be around afterwards. Be glad. I'll be here quite a bit today. I'll be here in the morning again, too. If you see me around, and just pull me aside, or you're welcome to get a hold of Tyler at IPPA at any time, or get a hold of me directly. We'll be glad to answer questions. I also have some hard copies of the slides up here, and I'll put them out here on the table. Otherwise, it'll be up on the internet. Thank you. Enjoy Pork Congress.